There's non-personal. I don't know. Yeah, right, yeah. Okay. Well, we all came from Johnson County, there's a big traffic jam, western ones, was it gone?
It was gone by.
Okay, it's clear.
Oh, that's good to know. It looks like it was back in traffic up both ways, so.
Told the direction of the truck.
Just
She said he would never make it. One in front.
Oh, I texted him with a picture of the intersection.
Steve, you shoot the front tank, you shoot the back tank, and the rest of the tank is Steve.
So,
Yeah.
No. Yeah, Daniel's brother and I, Matt, you don't get much, came in and sort of gave. So he's not a few minutes more around $250. It was great. They didn't say stuff, bro. We got no words.
Why am I lost?
But that's pretty easy. It's not complicated, rather than something that's chat. I don't think we watch. And I there's a lot of people who think like stagnation. So we're that crap. So studies do that.
Yeah, I have to. It's not gonna be so wow, it might be something like that.
That was just.
Okay, I'm sorry. Go ahead.
Right, right.
Okay, so I have. I think about 21/7, first we wanted service. Yeah. Can you also know running Russian that? I don't like the shoes, it's all passing. Yeah. So, but it was fun. This is a very fun place. Because I don't see Greece with them. Then I did not bring that really hard.
So this thing. Actually, show was so my train solution. Very much.
Yeah, but I'm sure you should.
All rise. The Kansas Court of Appeals is now in session. The Honorable Karen Arnold Berger presiding.
Thank you. You may be seated. Welcome to the afternoon session of the Kansas Court of Appeals. We're happy to have you all here this afternoon. We have some frequent flyers here. I see attorneys who have argued lots of cases, so I don't have to go through a lot of explanation. But, and you probably all know us. I'm Karen Arnold Berger. I'll be the presiding judge today, which just means that I keep track of time, but actually I don't even have to do that anymore because we have this new beautiful timer that will be controlled by Nikki Jackson over here. And it's quite the improvement over our last timer, which when I tried to use it myself, it would periodically just flash fire, which was not good. So you probably remember that happening before. So she will keep track of time. If you're the appellee, I need to know if you want to reserve any time. Let's see. To my right is Judge J.C. Hurst. She's been on our court. She's not the newest member of our court anymore. She's an older member now. And to my left is Jacob Peterson, who is a district judge in Saline County and is sitting with us by designation today. I'm going to go ahead and call the cases. Call the first case, State versus John Clark. I also want to make one explanation because I did it this morning and realized it probably looked like I was just schlepping around up here, having a lot of back pain. So if I lay back like this, I'm not bored with your discussion. I'm just trying to get comfortable. Okay, so State versus Clark. You both know we're familiar with the facts and know how to argue, so I'm not going to go into that. Go ahead. You are with Corrine, you are with John Clark, and Steve, you are representing the state, right? Okay. Did you wish any rebuttal time?
Yes, I would like 3 minutes of rebuttal.
3 minutes. She's got it.
That was the anticipation. Yes, good afternoon, Your Honors. Corinne Gunning, Lead Assistant Appellate Defender on behalf of the appellant John Clark in this case. The primary question I have put before this court, the first question is whether or not the district court abused its discretion when it denied John's motion to allow him to present the testimony, present the evidence that the child in this case had recanted an allegation against a third party offender in the same interview in which she accused John. I have presented kind of a legal question related to that about State v. Barber, the case regarding what a person has to prove in order to bring that evidence in. My position is that this court and lower courts have interpreted the holding of Barber, or that Barber did not fully state its full holding, given the facts of that case too narrowly, to give full credit to the full legal determination of the case it was basing its holding on, State v. LeClaire. So John, ultimately, I'm going to request that this court reverse his conviction and remand for a new trial with the inclusion of these allegations.
Do you think we would have to reverse prior interpretations of Barber in order to do that? It's a long
I didn't
pause.
go through all of the cases that have interpreted
Sure.
Barber. Obviously, Barber is it's a much older case. And so to the extent that there might be cases where there's courts that say a recantation is insufficient to meet on its own to meet the requirements of Barber, I would say, yeah, we might need to revisit those. Because the three pieces that the State v. LeClaire had placed in there is recantation alone would require cross-examination in compliance with the confrontation clause. Now, I understand that the court in LeClaire was interpreting the I mean, its holding interprets the Oregon Constitution, but it is pulling in case law from the US Constitution, and I would say that our Constitution does not have a lesser confrontation clause protection than the Oregon Constitution. So I think the court in Leclerc is saying, sets forth these three requirements, and then its ultimate holding in Leclerc is regarding only one of those three tests, because that was the facts in Leclerc. And the facts in Barber were the same as the facts in Leclerc. We didn't have a recantation. We didn't have proof of falsity necessarily. It was for that third test on whether or not there was some evidence of a prior false allegation, and the probative value of it outweighs the prejudicial effect. But
Let me back up for a second. You're saying that the defendant had the right to put her on the stand and question her about these prior allegations.
had the right to cross-examine her, confront her with her prior allegations that she recanted against the third person.
Oh,
And
I see, just during the regular.
yes, yes,
Not
and he certainly has a right to confront her as a witness generally, and so it would just be part of the cross-examination of her. And I know that the state has said that it would kind of descend into some sort of circus where they're proving that prior allegation. I mean, that's how the state can try their case. Really, it just requires that John be able to ask this person, well, in the same interview where you were accusing me of a sex offense, didn't you accuse someone else? Yes. Later, didn't you take that allegation back? Yes, I did.
And there was some evidence presented on all of that, wasn't there? That she perhaps didn't take it back, that it was family members that
Yes.
forced her to,
And I think
that
that,
it maybe was not a withdrawn,
right,
that it wasn't a false accusation, it was a withdrawn accusation.
right. I would say it's a recantation. She recanted her allegations against him for whatever reason. And that's perhaps why I'm making this argument, is that we have they went in.
Now you keep definitively kind of saying that she did, but the district court made that threshold determination that actually this evidence of recantation doesn't meet the threshold necessary to invoke the confrontation clause and overrule Kansas statute, right? Am I misreading the district court's ruling, or?
I mean, I think that maybe overreading it.
Okay.
More just that the opinion in Barber allows this type of evidence of a false allegation in a sex case to be presented once certain criteria are met. And that overrides the Kansas statute. And so because of the confrontation clause. And so that's the purpose for this rule in Barber. And the court is applying that reasonable degree of
Reasonable probability
of
falsehood.
falsity,
Right.
which is the test that Barber set forth. And so because that's the test that they had in front of them from Barber, that's the test that they applied, and they said that he did not meet that threshold.
I guess I just want to tease out, because what I'm detecting in your argument is that there's like this definitive position that she did recant, when in fact, I just want to clarify, the district court did kind of find to the contrary, and that it didn't reach that reasonable probability of falsehood, right? I mean, isn't that the nature of their ruling, that in fact there isn't a reasonable probability that she did recant? Isn't that the very nature of the ruling below?
I would disagree with that reading of the rule.
Okay.
Just because I think that we have two separate questions here. One, is there a recantation? And that is, a recantation is there's an allegation that person has taken back, has said is either no longer true, or they no longer are asserting that. Under Barber, there's a separate question. If we don't have, if we have a recantation or some sort of indication that the allegation is not true, the defendant has a burden to show that there's some evidence that there's a reasonable probability of falsehood.
So Ms. Gunning, you're arguing that they're separate, that simply the recantation itself should per se be able to be questioned, as opposed to the falsity.
Yes.
Okay.
And that is from I mean, it takes a couple steps together in my argument, which I understand the state's position on this, that Barber adopted the position that was set forth in Leclerc. And at the time, in the 1980s, lots of states were carving out this exception because of the rape shield laws. There was still this exception if there are false allegations. And so this court in Barber said, okay, we are also going to have this carve out and we're going to base it on Leclerc. But they just adopted that final holding of Leclerc, which is based on the facts in that case.
Sure.
But there's three parts and one of them is recantation.
Recantation. Okay. In that part, then my question is, should there be an inquiry as to whether or not there is actually a recantation?
I mean, I think a recantation is pretty easy to identify. Have they made a statement and then taken that statement back? By the general definition of recantation, I don't think there's much of an inquiry there. And we see that there are lots of cases where there isn't a recantation, but there's some question about whether or not a prior allegation is false. And that's what happened in Barber. That's what happened in Leclerc. It's happened in several other cases. And that's what they argued in this case, is that there's some discrepancies in the evidence. So to the extent that this court is not willing or doesn't want to fully just then adopt the full three pieces of Leclerc, I still think that John proved the reasonable probability of falsehood, or there's some evidence, which is what the court in Barber just requires, that you have some evidence to prove a reasonable probability of falsehood. And there are some pieces and parts within this story that don't quite match up, and there is some evidence there that makes this evidence relevant to the question, particularly given what I felt was kind of a smaller amount. It was a much shorter trial than often in these types of cases, but it was really just a credibility contest between this child and her allegations and John, who gave two different statements. And so it's
One of those statements was pretty much an admission of everything.
correct.
I mean, he gave details of what he did to her.
Correct. And then in his testimony before the jury, he explained why he had made that statement, and that those statements were false. And so to have a full credibility picture before the jury, this relevant evidence should have come in so that John could fully confront this child with her allegations and put the question of her credibility before the court, because there is a question of credibility when she has recanted an allegation against one and not another. And I understand that, the judge in this case had that full picture and made that determination. It's just my position that she abused her discretion in this case because John met his burden to prove a reasonable probability of falsity. So we would ask that this court find that a recantation meets this burden to require cross-examination, and so that this evidence should have come in on the recantation alone. In the alternative, that he met his burden for a reasonable degree of falsity, reasonable probability of falsity, and so that he should have a new trial with the opportunity to present this evidence.
Okay. Thank you very much. Mr. Obermeyer?
Good afternoon. May it please the court, the state appears by Stephen Obermeyer. If I may indulge myself and ask a quick question, is the presiding judge, is the chief judge always the presiding judge?
Yes. So, but I'm not the chief judge anymore.
Okay. So you not know that?
So I happen
Right.
to be presiding judge, but not
Okay.
chief.
All right.
Judge
Gotcha.
Warner is now chief judge. So if
That's
she were
right.
on this panel, she would be sitting
Okay,
here.
that's okay. Thank you for that. I always wondered that. The State versus Barber says the complaining witness's prior accusations are not always admissible. Such prior accusations are admissible only if a reasonable probability of falsity exists. The trial court must make threshold determination of that. And in this case, the trial court considered the competing evidence, the fact that the detective did a search warrant on the cousin's Gmail and found 40 to 60 images of child pornography on his email account, including prepubescent females in the nude performing sex acts with adult males. The cousin Skyping with other females performing sex acts with himself. The judge can consider the fact that two other people, the person that did the CAC interview and an officer who interviewed the victim, determined that she was credible and testified to that. The circumstances of the claimed recantation by to the cousins, the cousins have a grandma in common. So the claimed recantation is to grandma and victim's dad. Apparently it was recorded. Like, who talks to some kid and is recording it like, hey, did you really, did your cousin really molest you? This court has seen other cases where you have suggestibility of child interviews, and if Dr. Barnett would be all over that if the grandma ever bothered to turn over the tape, which she claimed to have and never turned it over. So that might be an adverse inference by not producing that.
So is the fact that there was a recantation part and parcel of the gatekeeping function of whether or not there's evidence to support this as a false statement? So, I mean, are they separate things? Or are they tied together?
I think the court looked at Barber and considered everything, the recantation, the circumstances of the recantation, all the evidence, and made that determination. And
You don't think that that recantation alone would be sufficient to establish a right to cross on that issue? An allegation of recantation?
correct. Not when she unrecants that it was to her grandmother and dad.
But then, I mean, that could then go before the jury, right? There was a recantation, there was an unrecantation. Doesn't that go to credibility? I mean, do we have to also have a reasonable probability of falsity if there is a recantation?
I think Barbara says the court has to find a reasonable probability of falsity. The court considered all that. The court was the gatekeeper on that, weighed the circumstances behind that, along with the other evidence presented at the hearing, and said, we're not going to have a sideshow basically proving that she's been molested twice, which would violate the rape shield statute if that came in. And to your question asked earlier, I think most, if not all, the cases applying Barker would have to be overruled if just one thing, recanting to grandma is going to be enough to do that. And the state wrote a motion in limine concerning all this. It's in volume 2, starting at page 8, and it's a pretty well-written motion that cites a lot of the unpublished cases. And there's been arguments that, well, the claim was stale, so it shouldn't be considered, or other reasons made why credibility should be weighed. But I think here the judge listened to all the evidence. She summarized the evidence and made findings that I do not find that there's a reasonable probability of falsity. And I also argued, if there was a proffer, it's just the fact that she said this to the grandmother and recanted. I'm not sure that's really enough as far as it relates to harmless error. I think the evidence was pretty overwhelming, where the defendant admitted to the KBI that what he did. He admitted to the social worker as far as what he did also. And it didn't take the jury long to find him guilty of the charges against him. So for those reasons, I would ask the court to affirm the judge's ruling on that. And I would just leave issue 2 on the brief, unless the court has any questions.
All right.
Thank you.
Thank you.
Just wanted to clarify, in Barber, the court pointed to lots of cases, but specifically pointed to Leclerc and says that the court held that despite the prohibition of the evidentiary rule, which is similar to ours, the confrontation clause demands that a defendant be permitted to cross-examine the complaining witness concerning prior false accusations under certain circumstances. And then the cite to Leclerc. And then in Leclerc, it says courts have uniformly stated that when a complainant has recanted prior accusations or they're otherwise demonstrably false, the trial court must allow the defendant to cross-examine the complaining witnesses regarding them. And then sets forth 3 circumstances in which cross-examination is required. 1, if the person has recanted. 2, the defendant demonstrates to the court that those accusations are definitively false. Or 3, if there is some evidence the victim has made prior accusations that were false, applying unless the probative value of the evidence outweighs its prejudicial effect. And that's an or as well. So those are 3 things: recantation, evidence of falsehood, proof that it is false, or some evidence of falsehood with the probative value versus prejudicial effect. Because of the facts of both Leclerc and Barber, only that third one came into play. My position is that this court in Barber was intending to adopt all 3 of those, only adopted the one because of the facts, and it has developed beyond from that point, so that the recantation alone should warrant cross-examination in this
What
case.
is what is the standard for recantation, right? I mean, you say recantation, district court says gossip amongst cousins and grandma.
Mhm.
Like, do you see what I'm saying? This wasn't a situation where she went to the police and said, I didn't say that. That really didn't happen. I totally lied, et cetera, et cetera. Right?
Right.
And I mean, how would a court determine what is a recantation and what isn't? And did the court actually determine here that there wasn't a recantation?
I would say that, again, just using the common meaning of the word recantation, did she make an allegation and then later say that allegation was not true?
To anyone?
To any affirmatively. I mean, I think if we have the evidence in this case that she affirmatively did say that to someone. I know there's other circumstances that are being alleged about the reason for that recantation. But I think that's a subject for cross-examination.
Okay.
So unless
There's no gatekeeping function for the court with regards to a recantation. If it's been established, there was a claim and it was recanted.
that
Point by someone, then there's no gatekeeping to. There's no more gatekeeping to that. But they don't get to dive into, was it really a recantation? Was it not? That's going to be left to the time of trial to figure that out.
my position would be yes. I mean, I think we'd have to have something from the person,
Mhm.
and rather than just, I mean, if grandma had just come to the police station and said, well, she told me not, and then the child continued to assert it once, there were further interviews. I don't think that's what's happened here. She was recorded saying, and I understand opposing counsel's position on that being weird. But it's what happened, and it happens all the time, is that we record people making statements. And so she made the statement, she said it wasn't true. And so I think that once that is done, I think that is enough to meet the standard of putting it in front of the jury for purposes of cross-examination.
So then the state's concerned that this becomes a trial within a trial of lots of different
Mhm.
allegations. I mean, what do you say to that? How would that be addressed at trial?
I think that would be a trial strategy choice for the state to make at that point. I think that all this requires is for John to be able to say, okay, well, you made these allegations against me. Didn't you make allegations to somebody else? Yes. Did you recant them? did you later say that that didn't happen? And that's sufficient. That's sufficient for cross-examination.
So it would be up to the district court to put boundaries around the extent of questioning in this area?
I can't see from a defense counsel's standpoint of more than that. I mean, that's enough to draw the inference that I think a defense attorney needs to
I mean,
draw.
it's enough. It doesn't mean that that's where it will
Right.
stop, though.
Right. And so I think then it's, you know, a court does have the ability to control its courtroom. But I think what the state's attorney is suggesting is that it turns into a mini trial within a trial. Did this other person actually abuse her or not? And that's the state's prerogative if that's how they want to address.
Your contention is the defense attorney smartly wouldn't want to get into that.
I would suggest that most defense attorneys, it would be enough for them to say, did you recant? And then that's enough for them for their closing argument to draw the inference that there's a credibility problem.
Thanks.
Thank you.
Thank you.
Thanks. We will take the matter under advisement. We appreciate your arguments in this case. We'll get the decision out as quickly as we can. The last case of the morning, State versus DeVries. Hi, the state is the appellant in this case. Did you wish to reserve any time?
Yes, may I have 5 minutes for rebuttal, please?
You sure can. And Mr. Glasser?
Yes.
Okay. Just to make sure. Okay.
May it please the court, Daniel Obermeyer for the state of Kansas appellant. Your Honor.
Both of you on the same docket. Has that happened before? We have all kinds of relatives here.
I consider whoever made the docket had a good sense of humor about it.
Oh, maybe.
At
I
any
didn't
rate,
plan it, but maybe Chelsea did. Okay.
Your Honors, this case presents an issue of whether the district court abused its discretion in granting a dispositional departure to probation for a presumptive prison defendant who was convicted of a level 5 aggravated battery DUI. It's the state's contention that the district court made errors in finding that substantial and compelling reasons existed in the defendant's acceptance of responsibility, in assessing his criminal history, and in finding his potential to change lives through community service. Just as a quick recap of the facts of this case, because it is relevant in the analysis as to whether the district court would have been forced to grant a departure. The victim in this matter was driving home late at night on a December night and was struck at a high rate of speed by the defendant, who had a BAC of 0.16, also had marijuana in his system. And the victim, Mr. Chad Wagner, suffered extensive and very serious injuries as a result of that. Broken ribs, a lacerated spleen, weeks in the hospital, and then many more weeks in rehab. It was traumatizing for himself, for his wife, for his children. And that's the impact that it had on his life. Meanwhile, the case was charged with aggravated level 5 DUI, aggravated battery level 5 DUI, excuse me. Also with possession of marijuana and a person in possession of a firearm under the influence of alcohol, and felony criminal damage to property based on this incident as well. Pursuant to a plea agreement where the defendant pled no contest to the level 5 aggravated battery, the state agreed to dismiss the remaining counts, and the parties were essentially free to open argue at sentencing. Now, the defense prepared a motion for departure, and I will leave that to the court's review. It's in the record, but it doesn't, to my reading, clearly delineate substantial and compelling reasons for departure. It does mention why it is the defendant has a prior felony conviction based on a failed diversion when he was a juvenile, and that's why he had a prior felony, which elevated his criminal history, making him presumptive prison.
So without that prior, would he have been presumptive prison?
He would have been border box, which is still presumptive prison, but there's different mechanisms by which the district court has to find, different things the district court has to find in order to grant him probation. So we are now on a presumptive prison, qua prison box, where the court, per the language of State v. Morley, Kansas Supreme Court case, has to be forced to go beyond the status quo and grant a departure. And
We know about the felony case that he was on diversion for and violated. What was he on diversion for?
it was a possession of either amphetamine or methamphetamine. The explanation that defense counsel gave was that he possessed an Adderall, but then failed that diversion, I believe because he was continuing to use under while on diversion. So it was not a complete diversion. The record will correct me if I'm wrong on that. But the court latched on to this fact, the fact that he had a failed diversion as a criminal, elevating his criminal history, and but for that would have been border box. And the state's first argument is that's not to the defendant's credit, and that should not be weighed to be substantially compelling as a factor to force the court to grant probation. The reason for that is because a diversion, this is a Missouri diversion, but I presented the statutes in the brief, and the reasons for the diversions in both states are essentially the same. You're giving a person that has no or little criminal history the opportunity to show that this was a mistake and that they can indeed go on without elevating their criminal history. They can have that case wiped away, dismissed. So the fact that someone's given that opportunity and then they fail on it, I don't think that that gives them more credit than, say, a defendant who goes to trial and is found guilty, or a defendant who pleads guilty and elevates their criminal history that way. So I think that that is, and that's distinguishable from other cases where the court says criminal history can be substantially compelling reason, because we're not talking about the length of, from the last time he was convicted, or whether or not it's aggregating misdemeanors, that sort of thing. It's important. So this is a chance where, this is a situation where the defendant was given a chance and then failed at that chance, and then it's imputed to his credit.
So you're raising the question about the diversion being the basis for a prior conviction. I mean, it's sentencing. Is there ever a situation where you mentioned aggravating 3-person misdemeanors to turn into a felony, or is there ever a situation where a district court should look at a criminal history and say, well, this felony isn't the same as that felony? And if so, when?
If I do think that you can look and see whether or not the felonies in the criminal history are similar to the conviction at bar, and if they are similar, and if they are similar, then I think that that would be a situation where a court would be less inclined to grant leniency.
Sure.
But in this case, where we're having substance abuse issues, and we have that even throughout the pendency of this case, that is not, in the state's view, a compelling reason to grant a departure.
So you're saying that because the underlying diversion and the reason why the diversion was violated and this offense are all kind of related to, or maybe very related to, substance abuse, that's the reason why the district court's analysis on whether or not this was a conviction based on diversion doesn't hold water? Is that essentially your argument?
Yes, and more fundamentally, it's just that the defendant shouldn't be given extra credit for versus a defendant who pleads guilty or a defendant who goes to trial and is found guilty. A conviction is a conviction is a conviction. So,
okay.
It was when he was a juvenile though, right?
I believe so.
I'm trying to discern the length of time between that diversion charge and the charge in this case. I can figure it out if you don't know.
I'm sorry, I do not know off the top of my head. But I believe it was when he was 17 is when that charge came about. I think he was 22 or 23 at the time of this. I'm sure Mr. Glasser will correct me if I'm wrong on that. The second reason is the defendant's acceptance of responsibility, which, taken in conjunction with other things, can form a substantial and compelling basis for departure. But in this case, it's the state's contention that pleading no contest to 1 out of 4 charges does not rise to a level which would force the court on that basis to grant a departure. Obviously, that would then incentivize every defendant to simply plead no contest, and then every defendant would have a basis for acceptance of responsibility on that.
It's your position in that because he was a presumptive prison and not a border box, right?
I don't think that the presumptive prison and border box makes much of a difference here, except that I can't appeal a border box decision. They're both presumptive prison, whether it's border box or presumptive prison. I hear a lot of people say, well, border box is kind of like a coin toss, but reading the statute, it's not. It's still a presumptive prison sentence. It's just that the conditions for the court granting probation are different. There has to be a treatment program. Community interest would be served, those various things.
Okay.
With a departure to probation from a presumptive prison sentence, the court has to have substantial and compelling reasons to do that, and which is why I'm emphasizing the court's language, force. It would force a person to do that. The final articulated basis that the court mentioned was the defendant's potential to change lives through community service. And I believe that's the state's condition that this is squarely on point with the decision in Thurr, where the defendant was a K-State student, but chose to drink and drive, and 2 innocent lives were taken in the course of that. In that district court's reasons for granting substantial and compelling findings of substantial and compelling reasons, it articulated that he was an exceptional young man with a future ahead of him. And that is in the same vein as finding that the defendant has the potential to save or change lives through community service. That potential is the definition of an ephemeral hope that is not something real and not imagined. So
if you find that third factor isn't substantial and compelling, I mean, isn't there supposed to be some room at sentencing for a district court judge to be moved to grant somebody the grace of probation as opposed to prison? Isn't that the whole point of the substantial and compelling issue? Because I'm concerned with, if we adopt your argument, that there's really not going to be that human element anymore in sentencing arguments. And I get that it's in the state's favor and it's presumptive prison and it's substantial and compelling, but it sure seems like what you're arguing would remove that element of sentencing. What do you say to that?
Well, I don't think that the district court has the ability to see into the human soul. And I'm not saying that to be glib or discourteous or anything. But saying that someone has the potential to change is true of anyone and everything in this world. The point of the Kansas sentencing guidelines is to have consistent sentences that similar situated people are being treated the same way across the state. And while the state does have, it is tough to fight against emotionality, where a defendant might appear remorseful or a defendant might appear pitiable. That still has to be weighed against the objectives of the legislature in having consistent sentences and predictability in sentences for similarly situated individuals. That's not to say that there's no room for mercy, but I think that there's a danger with just letting a court, as letting with law enforcement officers, go off of a hunch that they feel that this is the right thing to do.
Why not just make no dispositional departure part of the plea agreement?
I
mean, the state had all the power here, charged him with a bunch of felonies.
That is, I would say that's a better question for the prosecutor, but I am the prosecutor, so.
I know. It's okay. You don't have to answer it, but you see the dilemma here. You could have definitely avoided this, not you.
Sure. Well, no, I could have. You're correct, Judge. I think that whenever I write a plea Yeah, I'm not, and I didn't give that to give the defendant any false hope or anything, but if there's a situation where there are legitimately substantial and compelling reasons, then there's nothing I can do. My hands are tied and I'm not before this court at all. But I think that what happened in this case was that the judge did not base her decision off of truly substantial, compelling reasons. At least not as she articulated them.
I see.
And I understand the defendant's argument as to his motion, but I see that I'm out of time and.
Okay, I don't wanna put you on the spot. All right.
All right, thank you.
Mr. Glasser?
And may it please the court, I'm Peter R. Glasser, attorney for the appellee Mason DeVries. And we're not here to determine whether Mason DeVries did a terrible thing on December 12th of 2021. He owned that, and he admitted that he did that terrible thing. He did that through a no contest plea, and he essentially threw himself on the mercy of the court from there on out. I would note it's sort of an interesting fact. We're here before the court today. Tomorrow's the 1-year anniversary of the district court having granted Mr. DeVries this departure sentence. And we're here on the state's appeal. So they are the ones who bear the burden of showing that the district court in granting that departure motion abused its discretion. And there's no debate, there's no dispute. The Morley factors apply. That first factor of whether the factors cited were legally appropriate, this court has unlimited review of that. When it comes to the second and third factors of whether the third steps as to whether the factors were supported by substantial competent evidence or whether the district court acted reasonably in granting the departure ultimately, that's viewed on an abusive discretion standard. And I want to kind of talk about a little bit of the procedure in this case that I think should impact how the court goes through, in particular, steps 2 and 3 of the Morley analysis. So the state in taking this appeal only addressed the three departure factors that were mentioned by the court and then were included in the journal entry of judgment in this case. And that's, when I looked back at the record, it looked to me like the state just generally sort of disregarded or set aside the defendant's motion for a departure sentence in this case.
Aren't we only supposed to look at the reasons the court chose?
Well, so I know that the court did specifically mention, and as the most important factor, the acceptance of responsibility. And then went on to talk about the criminal history and how that was explained.
And one with acceptance of responsibility, I do believe we have case law on that a no contest plea where you get out of 5 other felony charges isn't really terrific acceptance of responsibility.
Well, so that's Morley actually addressed that. And I understand that Morley said, well, he didn't plead to all of it. And it was a no contest plea. But Morley also said pretty plainly that a no contest plea could be considered an acceptance of responsibility, especially in light of other evidence of a defendant's acceptance of responsibility. And this record is full of evidence of Mr. DeVries' acceptance of responsibility. He wrote the letter that was attached to his motion, and it was described in the motion as showing his remorse.
Right,
and
but
how
he
sorry
got all those other charges dropped.
Well,
Some of them are kind of gimmies. Gun while you're drinking, he was drunk, there was a gun, a pretty easy one to prove.
Sure. Yeah, but again, I go back to, I think the state has to live with some of the decisions that it made as a part of this case. And the state was under no obligation to engage in plea negotiations with Mr. DeVries at all. Certainly wasn't under any obligation to dismiss any of the charges against him pursuant to a plea agreement. But he still accepted responsibility for the primary offense in this case. And as I said before, he didn't just do that through a no contest plea. He owned it. He owned it in his letter. He owned it in the statement to the court, his apology directly to Mr. Wagner and his family for the injuries that he caused, the long recovery that resulted. He offered to pay restitution. And So I think with all of the evidence, that no contest plea is only part of the picture. With all of the evidence, I think his acceptance of responsibility is supported here in the
And
record.
he offered to pay restitution, but it was actually his grandfather that was
Well,
going to pay restitution.
Up front initially, so that he could get the money to Mr. Wagner as soon as possible with an agreement for him to repay his grandfather while out on probation. But again, the state, the motion was filed, and granted, it was filed the day before the initial sentencing hearing. The state did not file a written response. The state didn't even really address any of the issues, any of the factors that were raised by the defense in that motion. The court actually held two separate sentencing hearings that were separated by almost 100 days. And in that 100 days, the state again did not file any sort of written response to the departure motion filed by the defendant.
Can I ask you one question? Do you think changing lives via community service is a legally appropriate factor?
I think it is. So Führer was sort of a different situation than this. Obviously, there were two people who were killed in that case, but even just looking at how the appellate courts dealt with that, I think it was clear that the district court judge in that case made an error of law in considering the pre-guidelines statute, where he thought he was required to look at the characteristics and circumstances and potentialities of a defendant. And so he just sort of relied on that based upon that statute. And here, I don't think the court relied on that alone. The court looked at the fact that while the defendant was in custody between the sentencing hearings, he didn't just sit on his hands. He went and completed the decision points class. He joined the inmate worker program, which required a background check, good behavior, all sorts of things done by the sheriff's office before he could be approved for that. And they received evidence of that. And I think the judge looked at that and said, this is somebody who's really making efforts, and I can allow them to continue those efforts with a probation that includes this 200 hours of community service. And I do think, I mean, that I put it in my brief, community service is restorative justice, and I think it is consistent with the rehabilitative goals of the Kansas sentencing guidelines. So I think it is legally appropriate. And certainly it's a non-statutory factor. I don't think it could be relied on by itself, but in the totality of the circumstances and the big picture of this case, I do believe it was legally appropriate. And so when we got to arguments at the time of sentencing, the state really relied on the facts of the case, the presumption for prison that came back on the pre-sentence investigation report. And again, didn't argue against any of the factors or any of the evidence. The arguments that they raised in their brief about, as you just pointed out, Judge Hurst, about the dismissal of charges in the plea agreement, the no contest plea, not, a limited acceptance of responsibility. They could have made that argument in front of the district court. They opted not to. They could have attacked, they knew in the written motion that the defendant was going to raise this prior conviction and explain it to the court in an effort to show that, hey, but for this single Adderall pill that this young man possessed when he was 17 years old, 8 years ago by the time they got to sentencing, but for that, he would be eligible for a border box probation, which is not a departure. They didn't address that conviction or that explanation at the time that it was raised by the defense. And they didn't take any action to seek any clarification, any additional orders, any additions to the record when they were given the opportunity to do so after the court granted the departure motion and stated the basis for that departure on the record.
So are you saying they're raising this for the first time or on appeal? Or did
Well-
they file a motion for reconsideration?
I'm sorry, what was the last part, Judge?
So are you saying that they're raising these issues, their objection to those departure factors for the first time on appeal? Or did they eventually object through a motion for rehearing or something?
They did not, and I did not brief it as if they're raising those for the first time on appeal. I think they have the right under the statute to appeal the departure sentence, but I guess the point that I'm trying to
But
make.
your point is they never raised this with the district judge to consider.
Right, they never did, and so then I I think the district court should be presumed to have made necessary fact findings to support the factors that it set forth as the basis for the departure in this case.
Unless they make a request for additional and they didn't.
Correct.
Interesting.
Correct. And so this court's to look at the evidence without reweighing it, without replacing its own fact findings for that of the court, or consider evidence that might support a different result. And I think we kind of get to that in their reply brief as well, where they're asking you to look at all these different places where, again, they had those exhibits available to them. They didn't argue anything about that in the district court. I know they took exception with some of the things that were in the substance abuse evaluation. That was available to them. It was available to them on June 13th, just the way it was on September 17th, some almost 100 days later. And it's also worth noting that the sentencing court presided over this case in its entirety. It was the sentencing court is the same judge who heard the preliminary hearing. The sentencing court is the same judge who took the plea and was aware of the nature of that plea, that it was a no contest plea, advice of counsel, and then was also there for both sentencing hearings. And I also think it's significant that the judge took the time to say, I need to set this over. And I want to have this additional screening done for the therapeutic community, which he ultimately was not eligible for. I want to have that done and know what's available to me when we come back. But this was a court who I think was being very conscientious about trying to reach the correct disposition in this case. And so in their brief, the state says there were only these three factors that were adopted by the court. It's our position that there were additional factors, because the court did explicitly say in its ruling, I find substantial and compelling reasons exist to depart as argued in it's document 11, just a throwback to the gym system in Johnson County, but document 11, which was the departure motion. And doesn't just say that, but then says coupled with the acceptance of responsibility, the potential to change lives through community service, and this criminal history issue where, but for that, 17-year-old.
You understand the state's concern here. I mean, this, acceptance of responsibility. Luckily, this defendant had a grandpa who could put up the money to pay for this. Luckily, they had an attorney for the first drug issue so they could get a diversion. I mean, we're in a situation here where, gee whiz, it's really lucky. And then the defendant gets the benefit of changing lives through community service, where other people aren't quite so lucky, but they might have very similar scores on all of these things.
So, and I'm sorry, are you questioning the acceptance of responsibility on that basis, or just the overall picture?
I mean, you're painting an overall picture, and the judge cited these three things in the journal entry. And I think maybe the changing lives via community service is the one that's sticking in my craw a little bit. And then the idea of acceptance of responsibility, when we couple it with, a no contest plea and having money to be able to do these things.
I don't know, because I don't know that it was explicitly cited in the acceptance of responsibility that restitution was going to be paid immediately. So I
think it was. I mean, it was discussed that he was going to pay it now. But again,
it was
the
discussed.
question is, would it have been different if he said he couldn't pay it now, but wanted to pay it over time, or couldn't pay it at all?
Well, but I guess what I'm saying is I don't think the court ever explicitly said, I'm giving this to you because you are paying restitution immediately.
Right.
They certainly discussed how quickly restitution could be paid. And they went back in the journal entry and said restitution first, court costs, fines, and everything else later. But I don't think that was a.
So you think it was more about the no contest plea in exchange for dropping the other charges, the acceptance of responsibility?
No, I think his acceptance of responsibility was because of how he acquitted himself in court. I think he threw himself on the mercy of the court, and he acknowledged the wrongdoing. And also, I would also point, because we talked about family support and all of that, those letters that came in from his family, they didn't minimize his participation in, his role in what happened to Mr. Wagner on December 12th, 2021. They came into that with their eyes open and were still supportive of him. They know that he did drive under the influence and severely injure somebody. And I guess my point is he owned it. And the no contest plea is part of that analysis, but the rest of it, I think, is pretty strong evidence of his acceptance of responsibility. And the judge also noted, you're doing that knowing that the state is going to come in here, that the victim is going to come in here and request that you go serve 43 months in the Kansas Department of Corrections, and you still came in and did it.
And the victim did do that.
The victim did ask for maximum penalty under the law.
And the state asked for maximum penalty?
Yes, and there were some allegations, I think, that the court somehow disregarded the victim's wishes in that case. I think from the court's ruling, it's clear the court did not disregard those wishes, but
So did the state make a general statement that we don't think any of these departure factors are appropriate? And they may not have, I'm trying to get back to this
Yeah.
preservation issue and whether they're arguing this for the first time. Did they at the hearing object to any departure for any reason? They just didn't go into detail or?
well, they certainly, they may have made statements that departure wasn't appropriate. This is the kind of sentence that somebody in his situation, in his, criminal history for this severity level offense is supposed to get. They did not specifically say, we don't believe there's these grounds for departure. And I would go back to, for the acceptance of responsibility, Judge, they raised the issue on appeal, but they seem to have no issue with the acceptance of responsibility at the sentencing hearings. Because the prosecutor actually said, I understand it, I see it. He's, if he was not contrite or some other way, but when he says he's sorry, I believe him. And when he comes in here and he's contrite and he's got something to show the court, I understand why that would make this a difficult decision. And so when the state says that at sentencing and then comes back on appeal and says this never should have happened because he didn't really accept responsibility, I think it kind of cuts against their position on the appeal.
You don't have a lot of time left. Can I ask you one question? If you have this readily available, if you don't, I suppose I can look it up. Do you have the dates of offenses for when he got the offense he went diversion for, when his diversion was terminated, and when he was sentenced on that charge and finished whatever sentence he had on that charge? Do you have those dates?
I do not, Judge.
Okay.
So the PSI shows a conviction date, I believe, in November of 2017.
Okay, but we don't know what the date of the conclusion of his sentence in that case was.
No.
Wasn't admitted, wasn't talked about, or did the
Wasn't
judge
admitted.
have all of that?
Wasn't talked about. There was no objection to the inclusion of that conviction, so there wasn't going to be any documents produced by the state to prove it up or anything like that. But
Okay,
so I am out of time. I don't know if the
Right.
court has any additional questions.
no, thank you very much.
Thank you.
Okay, let's first talk about this preservation issue and why you didn't argue any of this to the district court so that she knew you had such a strong feeling about each of these things.
Well, if the court reviews the motion for departure, as I said in opening, it is not the model of clarity. Like, I was not clear that acceptance of responsibility or the reason why the defendant got his previous conviction, making him presumptive prison, why those were substantial and compelling reasons. And quite frankly, I didn't see ability to change lives through community service in the motion for departure. So that was a new one on me. But to answer your question in the shortest way, I do not know what the court is going to rely on until the court actually pronounce the sentence and why she's making the decision that she is.
Is the defense counsel standing there though saying all of these things and you're not responding, or?
The way I've
I'm
always.
just trying to think of the district judge, she's trying to make a decision. If she's only got one side making an argument and the other side not contesting any of those individual arguments, I would think she would assume that you don't have a problem with it.
I think that your summarization of what defense counsel argued is accurate in that he was saying his grandfather can pay this $10,000. He can pay his grandfather back. The defendant made statements that if you send me to prison, you're taking me away from my children. Please don't do it for that reasons. So that's those, when you're in a sentencing, it's not as if we're in the situation we're in now. It's my position at sentencing that the state gets its say, defense gets its say, and then the court, knowing the law, will make a decision based on that. So I don't, at sentencing, typically object to anything because we have, if the court does find substantial and compelling factors and grants a departure, then the statute permits the state to appeal that decision. So I don't think
You've also filed a motion to reconsider or a motion for more specific findings or?
I didn't consider a motion for reconsideration more necessary. I thought it was clear from the court as to what was articulated, what bases we were being relied on to make this decision.
Again, I'm trying to look at this from the viewpoint of the district judge, and what indication would she have that you all had such a strenuous objection to all of these items?
I did ask that the defendant serve
His time,
his
okay.
time, and the victim asked that he served his time, which is a very atypical thing for a victim to say. But
Okay.
in my experience, usually it's do some time, you do, or even give probation. I moved on with my life. I don't want this to trouble it, but it had affected him very deeply, and he took this case very seriously as well. Again, it's not until the judge makes her decision that I know exactly what's being relied on. So the defense can list all the reasons they think are substantial and compelling they want, but ultimately I don't know what the court's going to rely on to make its decision. And to go back to my,
I'm not trying to beat up on you, Mr. Obermeyer, but you're also, you're in there as a prosecutor thinking on your feet. You hear stuff that's raised that you don't think is right. Generally, you have a chance to speak up. Nobody's preventing you from voicing those concerns out loud, right?
well, Judge, I'm very slow-witted, which is why I like writing briefs.
So you
I don't-
obviously do take after your father.
I don't- Well, my point is I don't always catch everything that's
Right.
being said. And
Well, are you saying, I mean, what I caught you saying is, well, generally, I don't know where you practice, Mr. Obermeyer, but you're saying, look, generally, I don't get an opportunity for reply.
the judge, no,
Right?
oh, no, I don't wish to say, this district court always gives sides ample opportunity
Okay.
to say, do you have anything more to say? It's my personal feeling that if you say something once, why say it again?
Okay.
Fair enough.
But in that vein, I do think that when the judge took 96 days to make the decision to grant probation, I don't think that's a situation where she was forced by the circumstances as they existed at the first sentencing, say, to grant the defendant probation. And I don't think any of those circumstances changed on the way 96 days later.
But you had enough time to think about it some more, right?
Yes, and my position remained unchanged at that. And I'm not the one granting the departure. I don't have to be the one that's forced to make the decision. Either the language which the Kansas Supreme Court has in that the district court has to be presented with a picture which forces it to go beyond the status quo and grant a departure. Either that has meaning or it's ephemeral, to borrow another phrase. I am out of time, but if there are any other questions.
Thank you very
Thank you.
much.
I thank the court.
Thanks.
Thank you very much for your arguments on these cases. That will conclude our afternoon docket. We will take these matters under consideration and get you an opinion out as soon as possible. Thank you.
Rise.